Hello friends, welcome back to another video. So friends, today in this vlog we are going to share with you 8 important cases which is based on the law of contract and that should be on your fingertips while studying contract. If you are working as a lawyer or if you have a law student, this video is definitely going to be very helpful for you because in this vlog we are contain 8 very most important cases along with their detailed facts. So if you are going to write any questions in law examination, whether it's LLB or LLM or whatever as the case may be, this is very short questions and answer. So friends, let's keep watching your own channel and do subscribe our channel for getting any future updates. So let's start this vlog and see what are the most important cases that should be on your fingertips while studying any law of contract. So the first case is which belongs to the law of contract and which is a very important is belongs to the contract arising out of general offer and which is basically named as Carlyle versus Carbolic Smoke Ball and Company. See what are the basic facts of this case. In this case, the defendants advertised their product Carbolic Smoke Ball for a preventive remedy against influenza, and in the ad, they offered to pay £100 as reward to anyone who contracted influenza, cold, or any diseases caused after having used the product in prescribed manner. The plaintiff, relying on the ad, purchased a smoke ball and used the same in accordance with the directions, but she still caught influenza. After that, she sued the defendants to claim the reward of £100, and it was held that this being a general offer addressed to all the world had ripened into the contract with the plaintiff by her act of performance of the required conditions and thus accepting the offer. Hence, in this case, the plaintiff was held entitled to claim the reward because this is a general offer, and this case is also an illustration of communication of acceptance of offer by conduct. After that, we come to the intention to create legal relationship. This is a very one of the most important case laws which provides for as a intention for any contract usually itself creates a legal relationship, and this is one of the most important cases of Balfour versus Wolfer which is usually asked in the examination as well. So in this case, the concept of intention to create legal relationship was implied in the case of Balfour versus Balfour. In this case, the defendant, who was employed on a government job in Ceylon, went to England with his wife on leave. For health reasons, the wife was unable to accompany the husband Ceylon. After that, the husband promised to pay £300 per month as maintenance to wife for the time she lived apart. The husband, however, failed to pay the amount and was eventually sued by his wife. In the case, it was held that the husband was not liable to pay as there was no intention to create a legal relationship between the parties. As we know, there is a relations between both of them as a husband and wife. The important case is of Hadley versus Baxendley. In this case, the plaintiffs were operators of a mill that they had to shut down temporarily when the crankshafts of the mill broke. Plaintiffs then contracted the manufacturers of the engine to make a new engine on a similar pattern. A servant of the defendants was then sent to the carriers to transport the crankshaft to the engine manufacturers. The servant told the defendants that the mill is shut down, so the crankshafts must be sent immediately. The defendants informed that whenever the old crankshaft is given to them, the new one will be delivered by 12 o'clock its next delivery. So that due to the delay of defendants, the delivery got delayed and the mill had to stay shut down for several days. And in this case, due to the involvement of a third party, which is the carriers, the delay and loss could not entirely be blamed upon the defendants. Whatever damages or loss rose did not come to existence because of a direct breach of a contract by the defendants. Next important case is pertains to a minor's capacity to contract, which is generally known as Mohri Bibi versus Dharmodas Ghosh, and this fact is this case law is generally usually asked as to its basic facts, as to what the fact states about the case of Mohar Bibi versus Dharmodas Ghosh. So let's see this topic as well, and you can note down, take screenshot of this note. So in this case, the defendant Dharmodar Ghosh, as a minor, was the sole owner of his property. His mother was his legally appointed guardian, and one Mr. Brahmodat, who was a moneylender through his agent Kedarnath, lent Damodar Ghosh a sum of rupees 20,000 at 12% interest per year. The loan was taken by way of mortgaging the property. The same day this deal was made, Das Ghosh's mother notified the appellant that the Damodar was a minor, and anybody who would get into an agreement with him would do so at his own risk. Kedarnath claimed that Damodar Ghosh had lied about his age on the date of execution of this deed, which turned out to be untrue. Therefore, Brahmodat's appeal was dismissed and his request for the return of rupees 10,500 advanced towards him was also rejected. It was held that a minor's agreement is a void ab initio, and thereafter it became a prominent case law which is generally usually referred in the law of contract. Next important case is pertains to offer and counter offers, which is of Hyde versus Wrench. This is a leading case eliciting the concept of offers and counter offers. Offer is usually made by the first party to the second party, and if the second party also made an offer to the first party on the said particular concept or note, then it may be noted or may be called as counter offer. So what's the difference between them and what are the basic facts on this case? Let's see. In this case, Range, the defendant, offered to sell his farm to the petitioner Hyde for £1,000. The petitioner declined the offer, and the defendant again reinstated his offer for selling the farm at £1,000 to the petitioner's agent, stating that it is the final offer from their side. The petitioner, through a letter, offered to buy the farm for £950. The defendant refused to sell the farm at that price. The petitioner, several days later, offered to buy the farm at the initial price of £1,000. The defendant did not send any agreement to that and refused to sell the farm, because of which the petitioner sued for breach of contract. It was held that no contract came to rise between the parties, as the price was not agreed upon between them. Rather, offers and counter offers were exchanged. Next concept is of doctrine of frustration, which is the most important case of Krell versus Henry. So let's see what was held in that case. So in that case, the defendant agreed to rent a flat of the plaintiff to watch the coronation of King Edward VII from its balcony. The plaintiff had promised that the view from the flat's balcony will be satisfying, since the procession will be perfectly visible from the room. The parties corresponded through letters and agreed on a price of £75 for 2 days. Nowhere in their written correspondence did the parties mention the coronation ceremony. The coronation did not take place on the days the flat was booked for, as the king fell ill. As the king fell ill and the defendant refused to pay the whole sum of money that the parties had agreed upon between them for the reason, and it was held that it could be incurred from the circumstances surrounding the contract with the implied purpose behind the contract. So, due to the cancellation of the procession, the purpose of booking the flat was frustrated. So, this is known as the remoteness of damages as well, and the doctrine of frustration. Next case is of Lalman Shukla versus Gauri Dutt, which is pertains to communication of offer is necessary, because generally if a offer is not communicated, then it will not be deemed as a contract executed between the parties. So in that case particularly, it was held that communication of offer is necessary to constitute a contract. So in that case, the defendant's nephew went missing, and the petitioner, who was a servant under the defendants, was sent out in his search to Haridwar. After sending the petitioner, the defendant carried out an offer to the general public offering rupees 501 to whomsoever finds the missing boy. The plaintiff found the boy and helped return him back to his home. He had been paid the money he spent in going to search for the boy, like his travel expenses. And when he returned, he continued working for the defendant for about 6 months. After 6 months, he sued the defendants for paying him the prize money that was offered earlier. So it was held in that case the petitioner was not entitled to the prize money as he was only obliged by the duty he had as the defendant's servant to find the missing boy, and the reward was announced after he had already been sent. So this was also a prominent case of Lalman Shukla versus Goridat. Topic is of acceptance should be communicated. Like we see, offer must be communicated, same as acceptance must be communicated, which is held in the case of Feldhaus versus Bindley. In that case, the petitioner, Mr. Paul Feldhaus, wanted to purchase a horse from his nephew, but the price he offered to pay for the horse was less than that his nephew was willing to sell it for. The horse, therefore, was still in his possession, and the uncle communicated his offer through a letter saying, if I hear no more about him, I consider the horse mine at $13.50s. The nephew could not respond to the letter because he was busy with an auction on his farm. Though he asked the auctioneer, Mr. Bindley, not to auction the horses, he accidentally did. Mr. Feldhaus then sued the defendant for conversion of his property. The defendant argued that the horse was not actually Mr. Feldhaus' property as there existed no contract between him and his nephew at the time of auction because Mr. Feldhaus' offer was not accepted by his nephew and the nephew's silence cannot be considered to be an acceptance of the offer. So, an acceptance is also an important element to constitute a contract as well in terms of Indian Contract Act 1872. So friend, this is the most important cases which you must have on your fingertips while studying of law of contract so that you can given reply to the questions put up by your teachers during your college time or any lectures. So friends, if you are not subscribe my channel and you first time come on my channel, please do subscribe so that you will get all the new upcoming updates from time to time. Thanks for watching this topic.